Thank you so much for yielding, Ranking Member Neal, and I want to thank Chairman Smith for your support in bringing the Survivor Justice Tax Prevention Act before us today for consideration. And I absolutely want to thank Representative Smucker for working with me. It's been a long time coming as we've worked on this bill to support survivors of sexual abuse and ensure that any settlement award received on account of sexual abuse is not subject to federal taxation. When I've talked about this bill in public, and strangers were alarmed at the disparity and inequitable treatment of sexual abuse victims. And so it's been a long time coming, but here we are today. Currently, settlement payments made on account of personal physical injuries or physical sickness are excludable from gross income. Yet, many survivors face challenges proving that sexual assault resulted in physical injuries because they don't have evidence of quote, unquote, observable bodily harm and have been denied the tax exemption. At the core of it all, this bill is about fairness, dignity, and justice for survivors. The Survivor Justice Tax Prevention Act redresses this situation by separately enumerating harms caused by sexual abuse, ensuring that survivors do not have to be re-traumatized by proving so-called observable bodily harm. This bill recognizes that the harm is real and lasting even when it's not visible. That's why Representative Smucker and I have drafted this bill to make it explicit. No survivor should be asked to relive their trauma or produce deeply personal records to be treated fairly under the law. We also make it clear that when a judgment or settlement includes an admission that damages are on account of sexual abuse, then that written agreement should be sufficient evidence to benefit from the tax exemption. If the IRS has reason to doubt the legitimacy of the facts underlying the agreement, then they can challenge it. But the presumption must be that the admission is valid. Of course, sometimes settlements aren't explicit, that they are on account of sexual abuse. Someone might say pay a premium, for example, to maintain that silence. Even in those situations, a survivor should be able to benefit from the tax exemption and should not face undue hurdles proving that to the IRS. That's why our belts and suspenders approach is so important. We hear in the news about high-profile civil cases involving sexual abuse. I'm thinking about the accounts of trusted gymnast physicians abusing athletes and the victims of Jeffrey Epstein and many of his associates. But let's be clear about it. We need to acknowledge that abuse just isn't in the headlines, because for every case we hear about, there are countless others that remain unseen. Every time a survivor comes forward, it takes extraordinary courage in the face of personal risk, scrutiny, and cost. And I urge my colleagues to support this effort to make the tax code better serve all survivors who receive settlements after prevailing against their abusers by not saddling them with the tax bill or having to fight the IRS.